This is The Micro Effect. www.themicroeffect.com.
Well, good morning. Welcome to Connecting the Dots with Dan Happel. This morning I have on the line, on the call, Elias Alias, one of the founders of Oathkeepers and the founder of the Mental Militia. And also I have Doig on, who Don is the founder of the Fully Informed Jury Association in Montana. And we had such a positive feedback on last week's show because we brought up some of the concerns of a fully informed jury and the importance of jurors in the legal process. And we had so much feedback on that, we decided to do a follow-up show today. Last week, Roger Root, who was part of the legal team for the Bundys, talked about his involvement with Fully Informed Jury Association, and we kind of touched on it briefly, but our listeners gave me a lot of feedback that they were very pleased with the discussion and wanted to know more about it. So with that, I brought two of probably the experts on the subject into the conversation today. And we will be talking about how important jurors are in the legal process, why our founding fathers saw the need for a jury of peers to be able to evaluate the guilt or the innocent of people, and how this is a unique process that was until very recently very unique to the American judicial system. There's some ties to the British system, but really unique to the American system in as much as we were innocent until proven guilty. And that has been changing over the last, maybe 5 or 6 decades because of government plans or government programs that have made it difficult for people to defend themselves. And so with that, I'd like to welcome our guest, Elias. Welcome to the radio show, and then I'll introduce Don after maybe you give a little of your background and your information.
Good morning there, Dan. Good morning, Don. I'm just an old guy that learned a little later in life about civic responsibility, and I'm still learning, but back in 2003, I was at a Liberty conference, and I ran across this guy, Doig, who asked me if I knew about FIJA. That would be the Fully Informed Jury Association. And I had not heard of it, and I was an older guy, in my 50s. So I'm thinking, what was that? And he explained to me basically the idea behind FIJA. And then I learned he was one of the 2 founders of FIJA way back before the turn of the century. So I've been interested in learning about what some people have called the 4th branch of government, which is the jury. I've been real interested in that because as the founder of the Mental Militia, I realized, our country seems to be devolving when it comes to personal liberty, and some of our social and cultural institutions and traditions are somewhat under attack because of, let's say, international political pressures. And it seems if a jury can counter the effects of a bad law by rendering a not guilty verdict, that's actually a power that we the people still hold in our hands. And we're holding less and less power these days to protect freedom right here in America. But that jury can do an amazing thing. So I've been interested for quite a number of years in freedom, and in that interest, I've had to go into the hidden history and go into older American history, colonial history. And Don introduced me through his website, fija.org, Egypt, to a lot of old history that I wasn't aware of where this notion of a trial by jury came from, and why the founders wanted to be sure that we had that as part of our governmental experience. So with Oathkeepers, I was their editor for 7 years. I did step down a little over a year ago to focus more on the mental militia. But with Oathkeepers, I was looking at the beautiful idea that Stuart Rhodes came up with about teaching police and military about the true nature of that oath we all swear or affirm as we're entering military or police work. And telling those guys what they didn't learn in school and what they didn't really learn in the neighborhood, and what the police and military really are going out of their way to teach them about the fact that the oath is sworn to the Constitution itself, to that piece of paper, which is the written word and will of the American people. And that oath is not sworn to a government which came out of that Constitution, but which can include nefarious characters who work their way into political office and abuse the Constitution. So the oath is not sworn to the government. The oath is sworn to the paper, the Constitution itself. And that ties in with, I may sound like I'm rambling a bit, but that all ties in with the whole idea of we the people being the sovereign who did create our government and did regulate and enumerate the government's powers, and our duty as citizens to take a kind of keep oversight on what the government is up to. When the government passes laws that are not pursuant to the Constitution, the jury has the authority and the power and even the duty to go ahead and nullify that law in a trial. Not take the law off the books, but just to say, we do not believe in good conscience that this law is properly applied in this case, and we'll say this defendant is not guilty, and the government has to accept their verdict. So that's a huge power. So I've been excited about it, and Don and I have become friends over the years, like you and I, and in the fight for liberties in this country is so reassuring to know good, strong-willed men and women who will do all they can do to help our neighbors awaken to the powers, duties, responsibilities that we as citizens have. So that's about me and kind of where I'm coming from. I think Don has a very interesting history that I'm sure he can tell us about how he got into the idea of creating a fully formed jury association.
Well, yeah, and Elias, I have to tell you that the outcomes of the verdicts of the Bundy trials are a real strong vindication of the power of a jury, because the government in those cases had certainly the prosecutors, government prosecutors, and many of the agencies that were testifying were caught in blatant lies and caught manipulating the system to try to make the defendants, the Bundy Malheur defendants, guilty, and to force them into an untenable situation where they end up in prison. And if it had not been for juries in those trials, there would have been a significantly different outcome. And I think what we're going to try to do today is to make people realize how important it is, if they're called up for jury duty, to make sure that our listeners and people understand how powerful that position is and how important it is on the outcome of justice. Don, I'd love to have you get in now and start talking maybe a little about the history of the jury system and how the founders envisioned that, and then bring that into the more contemporary situation of today.
Okay. Trial by jury, as we know it, had its origins in England, probably as far back as Magna Carta. The idea that the jury has the right to vote according to conscience was something that was struggled over for centuries, and finally, with the case of William Penn in England, he was a Quaker, and he was arrested for preaching an illegal religion to an illegal assembly. The Church of England was the only legal church at that time, so Quakers were outlawed, and he went ahead and they were locked out of their church, and he was preaching to the crowd in the street and was arrested, brought up, and potentially it was a capital offense. And so when the jury was impaneled and presented the facts of the case, they decided that an injustice was being undone, and they refused to convict. The judge was outraged by this and held the jury in prison for several days without food or water or toilet facilities, and eventually and fined them, and some of them refused to pay the fine. So finally, upon appeal to the High Court of England, the decision came down that the jury had the right to vote their conscience and could not be punished for their verdict. So that was kind of the most important early case in England, and that transferred over to the colonies, where trial by jury was highly valued. And in the case of John Peter Zenger, for instance, he was a publisher who was charged with publishing materials which were critical of the royal governor of New York. And in that trial, the defense attorney actually argued to the jury that they have the power of conscience and power to vote not guilty if they think an injustice is being done by the prosecution. So in the end, the jury said not guilty and released him, and that's cited as an important case in American legal history. It goes down through the decades. The fugitive slave cases saw a lot of jury nullification, made it very hard to enforce that federal case. The Salem witch trials were shut down by a failure of the jury to convict defendant after defendant. The Prohibition was essentially shut down by jury nullification. The idea that it was illegal to traffic in alcohol was, and actually an interesting point here is that in order to justify banning alcohol, they had to pass a constitutional amendment, the 18th Amendment, to make that possible, because without a constitutional amendment, there was no constitutional authority to ban alcohol, and so it was illegal. They couldn't do that. So at least they realized at that point that they had to have a constitutional amendment to go forward on this. Juries refused to go along with it, however, and there were a lot of not guilty verdicts in cases that were brought. And finally, after 13 years, I think it was, they repealed Prohibition with another constitutional amendment, 21st. And I would point out that these days they do all kinds of prohibitions and activities which have no constitutional authority. And we need to have the juries getting on board with understanding what their powers are and get this sort of thing shut down. So for the last 150 years or so, the courts in this system have engaged in a struggle against the power of the jury, and there have been cases back and forth for 150 years, gradually decreasing the expectation that judges are going to tell the truth to the jury about their power of nullification. In the late 1800s, there was an important case that came down. It was called Sparf and Hansen versus U.S. That the Supreme Court held that while jurors still have the power to vote according to conscience and to vote not guilty if they think a law has been violated, that is an unjust law or an unconstitutional law, then they still have the power, but they don't have to be told it by the judge. The judge can keep that secret. And with time, judges have been doing more and more to discourage it and lying to the jury, basically, that they have to take a false oath that they will follow the law as the judge explains it. Now, that's false. It's a lie. Jurors still have the power to vote according to conscience and do what they think is right. Now, the judge is going to, and the prosecutor are going to try to kick anyone out of the jury pool who understands that they have the power of conscience. And they're going to be asking questions of potential jurors, what do they think about all of this? So you have to be careful, because you can't do any good if you're not on the jury. So you want to get on the jury, especially if it's a case that has implications for individual freedom. So first of all, understand that you have no obligation to volunteer information, and so don't say anything that you don't have to say. Don't explain yourself. Don't, just keep it to a minimum, yes or no, and hopefully you can get on the jury. If you do get on the jury, a couple of things to remember. You have to, in the process, the way things have evolved, you have to address the question of the insufficiency of the evidence. Say you don't believe the witnesses, you don't believe the police, you don't believe this or that, and so bring out anything that you can come up with that casts doubt on the prosecution's case. If you're inclined to engage in nullification, you have to also do that, so that because look, court cases have held it, as long as you're questioning the evidence or some aspect of the trial itself, you can't be kicked off the jury for that reason. So it's important that you do that, in addition to also arguing that the law is unconstitutional and we have the power to vote our conscience. And the basic FEJA message has to be combined with a questioning of the evidence. So just keep that in mind. Mm-hmm. And also, if the judge asks you, can you follow the law if you were impaneled, you can, even if you're pretty sure that the law in question is bogus, you can say, yes, I can follow the law. You can basically take what's called a mental reservation, and you can say, what you meant by that was, well, sure, I could follow the law. It's within my power to follow the law, but that's not necessarily what I'm going to do when it comes right down to it. And the judge can't demand that you turn in a conviction. It's not within his power. So as long as you basically do what you can to get on the jury, and then, play it by ear. Try to gently introduce your objections to the law along with questioning the evidence, and you can maybe do some good when you have the chance.
Mm-hmm.
The power of the jury to vote its conscience and to say not guilty to a bad law is the only real power that we the people have over the conduct of the government. It's the only real power that we have to say no to the government. Anything else is just begging someone else to respect your rights or do what is right. But if you're on a jury, you actually have some power, and it's powers that the prosecutor and the judges hate to see happen. But the fact is, you do have that power, and one should exercise it.
Well, and Don, one of the things that first of all, I want to tell our listeners, we are not intending with this conversation to imply that every judge and every court decision is unconstitutional. Quite the contrary. We just want people to understand that the jury has the ability to make sure that the judge and the trial information follows the real law, follows the constitutional law, and that they have the power to make, clarify whether or not that is the case. And, there are other members on that jury, so it's not like a person would be the only one with that opinion, and that certainly is the case with the Bundy trials, the outcomes of the Bundy trials. They were the people that were on the jury pools for those trials were very diverse, picked from a large group of people of virtually every race, creed, and color possible, and they ended up coming up with a very clear decision that the court had manipulated the information, and they found those defendants not guilty. So the whole idea, and Elias, you referred to the jury as a fourth branch government. I'm sorry, but I've been on a number of shows where I refer to the unelected bureaucrats and administrative roles as being the fourth branch government. But in fact, it's the most protective of the true law and the support of the rights of individual liberty that there are. So in any case, I digressed a little bit there, but I want people to understand we're not telling people to try to get on a jury and give everybody a free pass and find everybody not guilty, even if they are guilty. That's not the case. We're telling people to use the Constitution as a framework and understand whether or not these laws are being violated. And if, in fact, the Constitution and the ideas are being violated, then you have the right to make a difference.
Well, somebody, Dan, has to oversee the procession of development in the expansion of government authority. It was in Federalist, in the Federalist number 51, James Madison, who is called the father of the Constitution, put it in plain English and said, and I'm paraphrasing here, but it is in number 51 in the Federalist Papers, that the first obligation of a government is to establish control over the governed. And the second responsibility is then to monitor itself. Well, that's, of course, the basic premise of to govern. A government that can't control its governed is going to not last very long. But at the same time, asking a government to regulate itself, it's kind of like when the Senate has required twice that the CIA investigate its relationship to international drug trafficking. The CIA was asked to investigate itself. So 2 times in a row, and these have been published on the CIA's website, twice in a row, the CIA investigated its drug dealing activities and decided that it was not guilty of doing any drug transportation. Right. And so there's an obvious example where everybody knows now that the CIA was importing massive tons of cocaine into this country during the Iran-Contra scandal. And, I mean, it's no longer a secret. And yet the CIA could deny that. But we, the people, are the source of sovereignty, as we learn in our founding documents. We came together as people, and as Dr. Vieira points out, we had the authority to form or create a government, and we did, we the people. If we had that authority, we certainly have the obligation to regulate the development and activity of that government. What you have seen today in modern times is an erosion of any adherence to the constitutional requirement found in Article 1, Section 8, where the government's activities are clearly enumerated, its powers are defined and limited. But, for instance, in the Constitution, the government is instructed that to go to war, there would be a declaration of war by the Congress. Today, our Congress has rolled over. It doesn't. It just tells the president, you're going to do what you want to with this military, and you don't have to get a declaration of war to field an army in a foreign country. Well, that's totally unconstitutional, and it renders the wars, like the war I fought in Vietnam. That war was, now that history has cleared the air, that war was an international war crime. We had no legal business even being in that war. And a lot of veterans found that out too late, like I did. But so the people are the source of the sovereignty. We have the power to regulate how the government functions. And when you say we're not trying to color all courtrooms or all judges as being despots, at the same time, as Don alluded, back during the Prohibition years, our government decided that some way or another it had the authority to own your body.
Right, Elias, keep that thought. We're moving into a commercial break, but on the opposite side of that, we'll continue with that thought.
This is the Micro Effect. www.themicroeffect.com.
There was a mighty nation, blessed above all of creation. It was a rare and precious pearl, conceived in faith and liberty, home of the brave, land of the free. It was the envy of the world. But this shining city on a hill has turned from the Creator's will and let evil take control. Now the reckless men who lead them want to strip away their freedom and to steal their very soul. Now it's smoke and mirrors, switching bait, criticize and confiscate and let the guilty walk away. In this once righteous, godly nation, in the halls of education, they forbid a child to pray. They say we need to spread the wealth.
Well, welcome back to Connecting the Dots with Dan Happel, and today my guests are Elias Alias and Don Doig, and we are talking about fully informed juries and the right to challenge the court system through the trial by jury system to define whether or not laws are just and whether they are appropriate. And Elias was talking about when we went away on break, he was talking about how important it is that we realize how powerful juries really are. And that's absolutely correct. And one of the things that we want to bring out during this discussion today is how important it is for average citizens to want to be on a jury and want to be part of that system and take pride in being involved, because the reality is they can make a huge difference. They can protect the rights to life, liberty, and property in ways that very, very few people can do outside of the system. So with that, Elias, you were in the middle of a thought. Go ahead and finish that thought, and let's continue the discussion.
Thank you, Dan. I was talking about prohibition, where the government, for one reason or another, decided it could take ownership over the population's bodies. They decided they could forbid people, citizens, from drinking alcohol. So they made it against the law, called prohibition, and they went, that created organized crime in the big cities. But along the way, juries started noticing, maybe they don't have that authority. Maybe it's not constitutional, but the government can regulate what we do put into our bodies and what we don't. So juries began to release defendants with not guilty verdicts, even though all the facts of the case indicated that the guy was sitting there making moonshine on his property. When the juries let him go enough, the law had to be changed. That is the power of the jury. But, questioning authority is really a patriotic thing to do. And I'm not saying be against authority. I'm saying question authority to see if it is following its own constitutional mandate. You mentioned earlier, Dan, about the trials, especially the ones in Portland, where the juries just would not convict. And one thing that struck me like thunder was the judge, Judge Anna Brown, in Portland, Oregon, would not let the defendants display the Constitution in their shirt pockets and refused Ryan Bundy's request to give free copies of the Constitution to each member of the jury. That judge said no. In other words, she didn't want the Constitution in her courtroom, and she didn't want the defense to rely on the Constitution as part of its defense. So there is an example of a viable or legitimate authority vested in a judge, that authority turning authoritarian by nature, in its nature. That when government becomes authoritarian, then it becomes tyrannical. Authoritarianism and tyranny they're like synonymous. So the check on all that mischief is in the power of the jury to vote their conscience. And, I think it was New Hampshire, and Don can back me up on this or verify it. New Hampshire recently passed a law that in every criminal trial, the judge must instruct the jurors as part of the court's instructions to the jury that they have this authority and duty to question the law as well as the facts before the case. And that's the first step that any state has taken in recent times to ensure and preserve our rights as jurors, and to rein in these judges who habitually will tell a jury, if the evidence shows he is guilty, you must convict. And that is, as Don said, that is simply not true. That evidence may show that the man or defendant in question did violate a law. And yet if the jury felt in their conscience that law was unjust or was being unjustly applied in this case, then that jury can just cut the defendant loose. Here's an example: is the Hammond family. Two of their members are in prison right now under terrorism laws for doing a backfire on their ranch, and which is very common practice with ranchers and farmers out west. They had a mandatory federal sentence because they classified their crime as a terrorism act. So how are we going to control that kind of authoritarianism when the laws themselves are unjust? And the only way I know is through the jury refusing to convict. When enough refusals to convict pile up, the laws tend to change.
Okay. Part of that too, Elias, is that with the Hammond case, even the judge, the first judge in that trial, said that the laws were unjust and that he didn't feel that it was right that they were, they were subjected to a mandatory sentence under the law. And it wasn't until they had a second trial judge come in and overturn the decision of the first judge and increase the prison sentences of those people to, of the full extent of the law, the full extent of what they say the law is. And now they're in prison on something that I think most people in this country that know anything about the trial see as absolute political prisoners. There's no question that they are not guilty of any real crime and that it's being manipulated.
Well, that's true. And, recently I went down to Paradise, Montana, and witnessed a wonderful rally that was led by Cliven Bundy and one of his boys, Ryan Bundy, and Shauna Cox. And it was a great meeting, but they brought out a lot of this where the Hammonds, well, let me put it this way. Montana Senator Jennifer Fielder gave a wonderful speech there. She has researched into the nitty-gritty behind the conviction of these two guys, and has looked up the court records and the history of their plight under government authority, and she is taking her report to the U.S. Congress because it is so egregious what the government did there. And I will say this, I'm not the biggest fan of Pete Santilli, but I do love his spirit. And Pete Santilli on his website has a new video out explaining what the evidence connecting the Clinton Foundation with Uranium-1 and the BLM in Oregon, which was trying to get the Hammonds Ranch because the federal government wanted to list the assets under the ground on the Hammonds property as part of the national reserves or securities. In other words, our national debt, to a large degree, has been backed by mineral wealth that is established to exist in the soil or under the soil on properties and mostly out in the western states. Pete Santilli went to the BLM's website, dug up reports, and the approximate figure for what is contained in the earth on the western lands, including Alaska, is over $150 trillion, and this is by BLM figures. The federal government wants to own those rights to those minerals so that it can say to China or any other country, if you buy some of our debt, we'll back it with mineral deposits on our own land. So essentially has revealed why the BLM insisted that the Hammonds sell their ranch or part of their ranch to the BLM, and then offered them a deal about how much time they'd have to do in jail if they would go ahead and give up some of that property. This is how nefarious that Bureau of Land Management has been. And then I know that you're aware of the NGOs that are manipulating and influencing policy among our federal agencies like EPA, Forest Service, and BLM. It's like the BLM is actually being a tool for the United Nations Agenda 21 and for private interests such as the Clinton Foundation, which right now is being exposed. It's so wonderful how much is coming out that is exposing this kind of collusion and treasonous of fraud. So that the Hammonds case reaches all the way up to international business between governments. And it just happened to be the Hammonds case is the one that popped up. But prior to that, the Bundy's case popped up, and there's the same kind of mischief going on there.
Right.
Again,
Elias, I'm sorry to interrupt, but I want people to realize, too, that the reason for all these trials, the Bundy trial, certainly the Malheur trials, are that they were trying to defend the Hammonds because they felt that it was unfair and unjust for the Hammonds to go to prison and lose their ranch over something that, frankly, 20 years ago, government would not only support, they would actually, defend the right of a rancher to protect their own land. And now that's completely turned on its head. I'll do a little plug here, incidentally, for our Thursday night radio show on Republic News Network, because I have Mary Fanning and Alan Jones coming on, and they are going to talk about the connections between the Clinton Foundation and the Uranium One deal, which was very directly involved in the Hammond situation. And I have a map, a BLM map, that shows the proposed lands that would make up that wilderness area around Malheur, and it includes on that map the Hammond Ranch. So in other words, they had planned before anything happened with the Hammonds, they had planned to absorb the Hammond Ranch into that wilderness area one way or the other. So anyway, go ahead with your thoughts, Elias, and then let's get Don back into the conversation on the fully informed jury.
Right, Dan. That'll be a good show Thursday night because it's hugely important. It clears the air on whose motive was in play when these guys were even accused of a crime, but doing that backfire. So, that same judge in Portland, he wouldn't allow the Constitution in her courtroom. She also told, when she just sentenced Jake Ryan to a year, I think it was just last week, she sentenced him to a year for helping dig a ditch at the Malheur Wildlife Refuge when these guys were being confronted by FBI military police. And they wanted to dig a ditch, kind of like we did in the war. You dig a trench and get in it so you can avoid a lot of enemy fire. These guys were scared to death. The FBI was bringing in convoys of militarized weaponry, militarized snipers, and militarized equipment. And these guys were scared, so this young man, I think he was only like 19 years old, teenager, was there trying to help dig this ditch. The judge gave him a year, and when she gave him that year, she said, the reason that I'm giving this much of a sentence against this violation is because this young man shows no respect for authority. And there again, she showed her colors. She should be impeached, in my opinion, for saying something like that when she herself would not respect the highest authority of law on this land, which is the U.S. Constitution, that she refused to allow in her courtroom. So this kind of injustice brings the conscience of man to the fore. We see injustice going on through our court system, our legal system, and we as individuals are really the only ones that have the power to stop it. The government will not regulate itself or contain itself. It will not voluntarily diminish its power or authority. And in the past, 70, 80 years, under a lot of cultural Marxist deployments through our institutions in this country, such as the Department of Education, we have lost sight of the fact that the ultimate source of all sovereignty in our government comes right out of the sovereignty of the people themselves. And jurors who wake up to this, who realize they're not guilty both in a jury trial in which the accused is accused of violating a law that actually is unconstitutional, that is the highest exercise of conscience in a civic duty sense. And it's one of the best things that anybody can do. So I don't want to go too long here, so let's see if Don wants to touch up anything I've touched on.
Well, and I'll make a comment, too, leading into Don's input on this, but I think that most people have forgotten that government exists only to protect our rights to life, liberty, and property. That's the only legitimate purpose of government under our founding fathers. That's what they intended. And the fact that government has taken so much power under its control that now it controls the people rather than protects the people is wrong. And we need to return to the concept that government exists to protect our rights, not to give us freebies, not to control or provide for us. They're there to protect us, and that's it. Don, I really want to get you into this conversation again. Talk to us about that concept.
Well, let me get into a little bit of the history first. Denial of trial by jury by the British was one of the major factors that led to the American Revolution. What they were doing was rounding up people that they thought that were guilty of smuggling, for instance, and shipping them off to England to be tried by strangers in a strange land with no witnesses in their favor or anything else, and just railroad them into prison over in England. So trial by jury was mentioned in the Declaration of Independence as being an important factor in what led to the Revolution, and also they put trial by jury in the body of the Constitution once, and in the Bill of Rights twice explicitly, and additionally in 3 places in the Bill of Rights by inference, and that would be the 4th Amendment, Due Process Clause, and the 9th and 10th Amendment, which speak of that the people reserve themselves. And that certainly includes jury nullification. That's what the Founding Fathers said over and over again about trial by jury and how important it was. Thomas Jefferson said, quote, "I consider trial by jury as the only anchor ever yet imagined by man, by which a government can be held to the principles of its Constitution. John Adams, who was the second president, said, "It is not only his right, the jurors, but his duty to find the verdict according to his own best understanding, judgment, and conscience, even though in direct opposition to the direction of the court." John Jay, who was the first Chief Justice of the United States, said in a writ by jury before the Supreme Court, Georgia versus Brailsford, he said, "You, the jurors, have, nevertheless, a right to take upon yourselves to judge of both, and to determine the law as well as the fact in controversy." Alexander Hamilton said that in criminal cases, the law and fact being always blended, the jury, for reasons of a political and peculiar nature, for the security of life and liberty, is entrusted with the power of deciding both law and fact. So the judge is just there as a referee and as someone to offer advice to the jury as to what he thinks the law actually is. But it's up to the jury to go and decide what to do about it. I would point out that if you're on a jury, it's not just the question of guilty or not guilty. If it comes down to a hung jury, well, that's okay. That stops prosecution, and then the prosecution has to decide, well, are they going to go forward with this trial or just drop charges because it's expensive and embarrassing for that to happen.
Don, I hate to break in. I want you to continue that thought after the other side of the commercial break. We do have to break for a few minutes, but on the other side of that break, let's continue that thought.
It's about time you find out we're being lied to. They're attempting to control the mind that's inside you, hide you from the power that designed you.
This is the Micro Effect.
www.themicroeffect.com. You take the blue pill, the story ends. You wake up in your bed and believe whatever you want to believe. You take the red pill, you stay in Wonderland, and I show you how deep the rabbit hole goes.
There was a mighty nation, blessed above all of creation. It was a rare and precious pearl, conceived in faith and liberty, home of the brave, land of the free. It was the envy of the world. But this shining city on a hill has turned from the Creator's will and let evil take control. Now the reckless men who lead them want to strip away their freedom and to steal their very soul. Now it's smoke and mirrors, switching bait, criticize and confiscate and let the guilty walk away. In this once righteous, godly nation, in the halls of education, they forbid a child to pray. They say we need to spread the wealth. They pretend to guard the health of the feeble and the poor, while the hand they hold behind their backs confuses and conceals the fact that the wolf is at the door. There's an unseen hand that pulls the string. It makes his little puppets dance to every song he sings as the night rolls in on a rising tide. Look beyond the shadows, behold a pale horse ride. They claim to seek a new
Well, welcome
world
back
order,
to Connecting the
without
Dots
borders.
with Dan Happel. Today, my guests on the radio show are Elias Alias and Don Doig, and we are having a discussion about how important the fully informed jury and the ability by jury to nullify laws that they see as unconstitutional. And Don, you were in the process of telling our people, our listeners, much about the history behind the idea that a jury is the ultimate line of defense against tyranny. And so I would like you to go ahead and finish your thoughts on that regard.
Okay. When you sit on a jury, you should understand that any one juror has the power to hang the jury, and if you can't come to a unanimous acquittal in a case where that would be appropriate, then you should be encouraged to hang the jury with as many people as you can get to go along with you, and that stops prosecution. So that can be a good thing. If you think that's what the situation in justice requires, then go ahead and do that. Also, you should understand that it's a mistake for the jury to think that, well, we're going to find the defendant not guilty on most of these charges, but let's give the government a little something. Let's just give them minor conviction here. And if they make that mistake, then the judge often will turn around and just slam the defendant with what would seem to be a sentence way out of proportion to the crime that the jury thought they were convicting them of. So if you've got a political prosecution going on that seems like the government is doing something that it has no business doing, then just say not guilty on all charges and try to convince everybody to go along with that. Because you just can't trust the government to do what is right by and large, unfortunately, in this day. Also, if as a juror, if you think that if you have any idea that the government is holding evidence that the defense wants to introduce, but they're not allowing it, then you should just automatically say not guilty if that is the case. The government is just turning around and abusing people's rights in every which way imaginable, and if you have a chance to stop that, you should try to do that if you can. Was there another question that I should address?
Well, Don, one of the things I think it's important, certainly on the Bundy trials, at least in the first two trials that Malliard and then the first Bundy trial, there was an awful lot of defense evidence that would very definitely prove, be on the in the favor of the defendants. That was told by the judge that it was unallowable, and you're absolutely right. If in fact a defendant is not allowed to defend themselves with facts, and you have a judge that won't allow those facts to come forward, that should be an automatic indicator that you need to find a not guilty verdict, because that's a railroad. There's no two ways about it. That defendant is being railroaded into a guilty verdict because they're not allowed to defend themselves in any reasonable way. And that certainly happened several times with the Bundys, and thank goodness they had a jury that was making the decision because of those jurors were very sympathetic to that. They recognized that collusion on the part of the prosecutors and the federal agencies, and as a result, they came up with a not guilty or a hung jury verdict on all those counts. So it's very interesting. Your comments are really right on the button on this thing. And Don, all I can say is that your background, your history of telling our listeners about our founders' intent on juries is really, really important, because I think a lot of people try to avoid jury duty. I think that's a real mistake. I think they should try to be on. If you're given that opportunity, it's a responsibility and an absolute honor to be able to serve as a juror.
Yes, that's right. it's the only real power that we have over our government. And as it becomes more and more tyrannical, we have to buckle down and try to do what we can, and that comes down to jury nullification.
Absolutely. Will you kind of talk a little bit about some of the things that that your group has tried to do through legislation, and some of the things that you've tried to do to make that fully informed jury and that nullification codified as part of law, certainly in the state of Montana, if not nationwide?
20-some states already have jury nullification provisions of one kind or another in their state constitution. These are normally ignored, but the fact is they remain in place. And in Montana, there is such a provision. It refers, in Montana's case, as in majority of the others, it refers to libel specifically, which the government used to use as a mechanism to their opposition, and commentary in the media about what they're doing wrong. They would try to use libel laws to suppress that. So many state constitutions already go out of their way to say that the jury is the judge of the law as well as the facts in libel cases, and 4 of them have it as just a general statement. They have the right to a general verdict, which is judging law as well as fact, and several of them say they have the right to judge the law as well as the facts in libel cases, as in all other cases. So it's already there. It's just the problem is they're ignoring it. Several state legislatures have introduced legislation that would require the judge to tell the jury that they are judges of the facts and the law, and it's passed out of one house in a few cases, and with the exception of New Hampshire, it has not yet passed. New Hampshire has passed a law that says the jury is the judge of the law as well as the facts, and the judge has to tell them the truth about that. Judges were still ignoring it, so they've now got another one introduced that makes it more explicit and more hardcore. We'll see how that turns out. But it's the basic idea: the judge has to tell the jury the truth about their powers.
Good. Well, that's something that under our Constitution, really everyone has that right. But when we've gotten to the point where we have to start reaffirming those rights through state legislatures, and I think it's important that to note, and you just did, that there are states that are starting to recognize that important role of the juror and codifying it within their state law. And I think, certainly with some of the federal overreach on agencies like BLM and Forest Service and some of these organizations that are part of the government, is important that we have that right, because it will reel in that overreach if we do have fully informed juries that are willing and able to, let's say, challenge the right or the efficacy of those laws. So, Elias, I'm going to make, at this point, I need to do a little bit of a plug for Debbie Boscalupi's Radioactive Wednesday, which will be on tomorrow from 9 to 11 Mountain Time. And Debbie's sister is going to be hosting that show tomorrow. And she's going to have a guest on that show who is going to be talking about child trafficking and how the cryptocurrencies are being used as a way to fund child trafficking. And this should be a really important show, because we just recently had a show on talking about cryptocurrencies. And it's important that we realize all the ramifications of all the different things that are happening. So that is Radioactive Wednesday. That'll be tomorrow from 9 to 11. And I look forward to hearing that show. And I know Debbie's sister, Kristen, is going to be the host on that show. And this is her radio debut, and I look forward to hearing it. So anyway, with that, Elias, let's get back to your discussion about how important it is to reel in all these federal agencies that are obviously out of control. And I really want to talk about the role of international courts in how they are starting to exert pressure on our national court system, and that pressure is absolutely unconstitutional. And there are judges in our country that actually want to recognize international courts, no matter whether it's constitutional or not.
Well, Dan, when it gets to international, our U.S. Constitution was written for governing the American people. It is not written for governing anybody else's country. It is not written to become a member in any international legal system. I'll give you an example about the United Nations. They have this creature called the World Court. The World Court, a couple of years ago, got involved in a trial in the state of Texas and literally told that court in Texas what the international law required in that court's decision. The court, being in Texas, decided to ignore the United Nations World Court and went ahead with their proceedings as they wished. But the fact that the World Court, under the authority, quote unquote, of the United Nations, would seek to interfere with the process of a United States court is totally unacceptable. And as you point out, Dan, we have too many politicians these days that are actually globalists in their psychological perceptions. They're actually globalists. And they want a one-world government, and they're working toward that. But of course, I'm sure all of your listeners already know that. What we can do is refurbish the American public mind with the idea that we are the sovereignty, we the people. We have a document that does not involve management of other countries, and we have our government has every obligation to protect its sovereignty. Our states are required to respect their sovereignty, and the individual is required to respect his sovereignty. This goes back to Thomas Jefferson's. I just love the guy when he was talking about unalienable rights. He was saying, in effect, that our Creator endows us with certain unalienable rights, and then he implies throughout all of his life's work that those unalienable rights are not subject to any man-made government. All governments began initially first in the mind of man. They are created just like corporations are created. These governments are worldly governments created by the mind of man. They are not comparable in authority or sovereignty to the divine gift of unalienable rights that each of us on planet Earth is born with inherently. So when it comes time to recognize injustice being done, like what was happening down there in that last Bundy trial, when the prosecution becomes so egregious, so disrespectful of the rule of law, that it will literally stand in a courtroom that is trying to be on the prosecution's side and embarrass the court so greatly that it is actually the prosecution is committing crimes in court. The name first up is Steve Mowry, who was leading the prosecution of the Bundys. By the time he got caught in all his lies, Judge Navarro, who had been giving the prosecution everything they want and who had been denying the defense much of the material for the defense, she finally had to back out and say, guys, I'm not going and crash and burn in hell with you guys. You are guilty of crimes in this court. Crimes against the people, crimes against the judiciary system. And I was watching Councilwoman Michelle Fiore just recently be interviewed on the Las Vegas Review-Journal, where she has said that obviously because the judge dismissed these charges owing to the malfeasance and the maliciousness of the prosecution, she dismissed the charges with prejudice, which not only means that the Bundys can't be tried for this again, it also means that the guilty parties, there's two of them on the prosecuting team, that have committed crimes in the courtroom. And they are now liable to be either sued or have charges, criminal charges brought against them. And I'm sure with Larry Clayman on the hunt there, and with the good work Roger Roots has been doing, and with the thanks to the help of the internet, the information is getting out there well enough to where I'm expecting criminal charges to be filed at least against Steve Mowry, the lead prosecutor. And the jury, had this trial actually gone to a jury, the jury would have really, if they had any conscience at all, they would have set the Bundys free anyway, just like they had refused to convict so many other defendants in the tiers of the Las Vegas trial and the Portland trials.
Well, and Elias, I fully agree with you on that. And the thing is, our court system has to be above, let's say, the lowly ability or the lowly control of the process to the point where unfair verdicts are being levied against people. And this trial was certainly an example of just exactly how convoluted the prosecutorial process, as well as the federal agencies testifying, how convoluted and how illegal those activities were. And that's where an important part of this whole process is the ability of the jury to see through that. And I believe had they gone on and gotten a jury verdict out of this, and it hadn't been stopped where it was, I think the jury would have exonerated these defendants anyway, because it became clear that things were being hidden, that information was being distorted, and that the defense was not given an opportunity to fairly defend themselves.
Exactly. She said as much. Her statement, her panel statement, was very blistering on the prosecution. She indicated that it was atrocious behavior. They forgot every principle of justice. They were like perfect little government robots, hell-bent on convicting people for the benefit of federal ownership of land, but also for the purpose of demonstrating that we, the little people, must bow to Caesar. We must respect authority, even if we don't understand why it is being ridiculous. So, again, that Judge Brown in Portland, where she just said it in plain English, there's so much of that going on. And it is what we are not being anti-government. What we are being is anti-criminality in government. And when you've got people like Henry Reid sitting in a position of senatorial power, who is in collusion with private industry for personal profit, it gets so deep and murky that finally the people ourselves must just wake up and confront it. And as Steve Earle put it in one of his songs about revolution, he's accusing the American people of saying, letters to the editor and cheating on your taxes is the best that you can do. And he's kind of asking that as a question. Is that all you can do? Cheat on your taxes everywhere you can and write letters to the editor? Well, Don's message at FIJA is, hey, get on a jury. Help stop this ridiculous oppression of people who are simply being charged because they violated a law that is not, well, it's a victimless law. Let's take my favorite example is the marijuana laws. The government simply says, thou shalt not, because we said so. But in reality, the government has no authority to tell anybody what they can put in their body. It has no authority to force anybody to take a vaccine. But yet, you have state governments and the federal government at times is asserting this kind of ownership in their unending quest to control human behavior. And they say they're doing that for the greater good of society. But what they're doing is trashing the entire Bill of Rights. They're trashing the purpose and the intent of the written Constitution, and they're leading this country astray. And the judicial branch is hugely guilty of doing this. I like the anti-federalist papers, these guys like Brutus and various others, Patrick Henry. They're sitting there questioning all of this during the Constitutional Convention. They're saying, hey, do you really want to give this kind of power to a small group of people when maybe the states should have more power and the central government should have less power? Well, they lost by and large, but their contributions to the decision-making that formulated the Constitution had a great effect. And we see today in modern history that the anti-federalists were much more correct than James Madison and his gang. And I don't have a lot against Madison except he sidetracked a convention to doctor up the Articles of Confederation and came up with this idea, and he sold it to George Washington and Ben Franklin. Let's have a more powerful central government that can take care of all these conflicts between the states and provide protection, with the military and postal service and all this. Let's do that. And the anti-federalists were saying, yeah, but you got problems here. You get the wrong guy in the seat of government power, he can do weird things. And again, I'll bring up Harry Reid's name. Guilty as sin on so many counts. Collusion with the Soros liberals, and he's made a mockery of the entire legislative system. But we the people can rise up by refusing to convict on marijuana laws. If we could put an end to this insane war on drugs, that's a huge chunk taken out of the militarization of our police. I don't know if people know
Elias, we've got a commercial break coming up. Please hold that thought, and on the other side of the break, we can continue with that discussion.
This is the Micro Effect.
www.themicroeffect.com.
And we are, as a people, inherently and historically opposed to secret societies, to secret oaths, and to secret proceedings. For we are opposed around the world by a monolithic and ruthless conspiracy that relies primarily on covert means for expanding its sphere of influence.
It was 1776 when the founders signed the writ of independence from the Brits. It was revolution. Now an enemy from within would enslave us all again and deprive us of our rights in the Constitution.
Well, welcome back to Connecting the Dots with Dan Happel, and today we have our guests on are Elias Alias and Don Doig, and we're talking about fully informed juries. We're talking about jury nullification, and we were talking also about how there is a move afoot to subvert our constitutional court system to a world court system. And Elias, you had mentioned this case in Texas where the world court came in with a decision that the Texas court did not fit their parameters. And I'm familiar with that case. That was a case where a several-time murderer who was an illegal alien had come into the state of Texas and had had another murder there, and the state of Texas had arrested and then they tried him, and he was on death row, and they were challenging Texas's right to use the death penalty to get rid of a convicted murderer who was illegal alien. And in reality, this world court coming in like this is absolutely unfathomable under our Constitution, and it shows just exactly how far we've gone down the wrong path when collectivist countries, the UN is a collectivist system, there's no question about it, and they want to institute a world socialist / communist / feudalist system where we're controlled by a very few people at the very top, international banksters who will control everything. And we will be living under a collectivist system which will virtually destroy the Constitution of the United States as we know it. And that court case was certainly an example of how they tried to come in and influence our local courts. So with that, go ahead and continue your thoughts. Sorry I had to stop you during the break. Continue your thoughts, and then we'll get Don into the conversation on what he sees that we can do.
Well, thank you, Dan. Your take on this totally coincides with my perception. I've spent a lot of time over the years looking into the history through publications at the NEA, U.S. Department of Education, the great foundations like Ford, Carnegie, Rockefeller, etc., and their impact on the social institutions that arose naturally from the traditional American way of life. All of our traditional ways of life, including the sanctity of the family, the ownership of your home, property ownership, states' rights. All of this is under attack, and that attack is being directed in many ways by various parts of the United Nations and their plans, especially this Agenda 21 business. So we're confronted with that. We're confronted with the fact that the Federal Reserve System is in bed with United Nations programs, and they've got the money, they've got the purse, and they've got the sword. They've got the police power and the military power, so that they can take and force a citizen at the point of a gun, such as, it happened during the civil rights demonstrations of the 60s, the anti-war movement, when students would get together and chant, give peace a chance, while they were opposing our war in Vietnam. The government would bring out the cops and battalions, and they would even bring out troops. So the government has this monopoly on force, and the people really don't have much left with which to defend the principles of liberty that are supposed to be protected by our Constitution. I will look at the United Nations Bill of Rights. It's called a Bill of Rights and Duties. And again, back to what Nixon said in Federalist 51, the objective of the government is first place is to control the government. And after that, it's expected and hoped that the government will control itself. But history now shows that's not possible. No government ever controls itself. So we, the people, are left with this responsibility. And it's not only to oppose corruption in our local communities and in our states, but even in our nation. And finally, we have to oppose it now coming at us from international bodies. NATO is another one that's a good example. But, you know, it's international in scope, and yet what the mental militia teaches people is, our first premise is each one teach one. And I'm talking about teaching the history of America, how the states came together as 13 sovereign nation-state republics, each with its own constitution, each empowered to send a delegation to a conference. And they came together in compact and created the federal government through that constitution. As John C. Calhoun, who was the 7th Vice President of the United States, said in 1831, the error is in the assumption that the general government is party to the compact. It is not party to the compact. On that Constitution, there is no signature whatsoever representing the federal government. The only signatures there were 13 sovereign nation-state republics who created it, and as a result of creating it, are responsible as the states to control it and keep it within the enumerated powers that the Constitution lists. Under the Constitution, there would be no BLM managing any public lands in any state, or only it would be managing public lands and territories. But once a state is brought into statehood, or territory is brought into statehood, according to law, the federal law, the federal government is to, in a reasonable time, is the term they use, in a reasonable time is to turn over the management of public lands to that new state. And, 15 or 20 or 25 years for this to allow the state to build up the infrastructure to manage public lands, that would be a reasonable period of time. In the western states, it's been over a century, and instead of turning over the public lands to management by the states, the federal government, being greed mongers that they are, they have decided to expand ownership and control of public lands in the states. So that's the big debate on the what I call the ranch revolution. These ranchers are tired of being put out of business over this kind of silliness. They're tired of having their way of life totally destroyed. There are people going to prison or being abused by government agencies. And the people are just tired of it. And they're rising up. And fortunately, operations like FIJA, Fully Informed Jury Association, are having an effect. And I would like to say this about Don's organization. You can go to fija.org. It's FIJA.org. And download flyers there that you can take to the printer or print them yourself and pass these out in communities. You can leave them at bus stations or in restaurants or on bulletin boards. But you just print these things out, download them right off the FIJA website, and pass them around. These pamphlets, the flyers, will explain to the public who, like me, before I met Don, I'd never even heard of jury nullification. Most people don't know that they have this power. Most people don't know how powerful that power really is.
Yeah, you're right. You're right. And certainly at the stage we are right now, I think through the Obama administration and up until a year ago, we were moving at light speed toward a collectivist system. And our system was always designed to make sure that the sovereign, the citizen was sovereign, and that the rights of the individual always trump the rights of the collective. And there's a real logic to that, because if you don't have individual rights, you won't have rights as a collective either. The reality is, if they take away your rights to life, liberty, and property for the individual, and supposedly give those rights to the collective, someone is going to be administering those rights, and that is the powerful at the very top. And that's why it's so important to retain our rights as the individual and make sure that people understand that the individual is sovereign, should be, and we need to protect those rights, because only under our system do we protect the rights of minorities against the overreach of the majority. That's why our founders believed in a republic and not in a democracy. Don, I want you to tell our listeners, let's talk a little bit more about what you see that can be done to expand this whole concept of the fully informed jury. I know Elias just talked about that, but I would like to hear your perspective as well, and see what you think can be done to expand the whole concept of jury nullification and the fully informed jury.
Well, I can see at least a couple of immediate reforms that need to be done. One is if you're charged in federal court with a misdemeanor, and it has a potential sentence of 6 months or less, you don't get a jury trial. And then they turn around and multiply charges, multiply misdemeanor charges, so that you can spend several years in jail with no jury trial. That's wrong, and that needs to be changed immediately. The second thing is the whole process of jury selection, which is voir dire. This should mostly be abolished. The only thing that can properly be done in jury selection is to eliminate any prospective jurors who have a direct conflict of interest. Say they're married to a defendant or have a business relationship with someone involved in the trial. Other than that, voir dire should just be ended. It's a way for the prosecution, especially, to stack the jury with people who will support the government. And if you have any idea of jury nullification and they find out about it during the voir dire process, they will eliminate you from the jury pool. So the best thing that could happen would be to just eliminate voir dire pretty much totally, and stop the government from stacking the jury in favor of the prosecution, which is what goes on. The jury defense tries to counter with their own jury stacking in response, but let's just eliminate the whole process. It isn't fair, and it's not delivering justice. Beyond that, I would like to see widespread application of federal laws in state statutes by the legislature, so that the judge has no choice but to tell the truth about jury nullification, and to allow the defense the opportunity to argue jury nullification to the jury without contradiction from the judge. We can get those things done. We'll be a lot farther ahead, and at the same time, if this happens at the state level, then in effect possibilities of state nullification of federal laws become much more possible. So keep in mind that if you sit as a juror, you have the power to put the kibosh on a lot of what the federal government is doing, as well as the state government. So I guess those are the two major that I can think of right now that need to be done.
Mm-hmm. Well, and your comments, and this is something that Elias and you and I have all talked about to a certain extent, is the impact now of international courts on our state and federal courts. How do we counteract that? How do we fight that system? Because that is totally beyond the realm of constitutionalism, and it is to the point where those things are happening more and more every day. What can we do to counteract that?
Well, our government officials and the people needs to just say, we have a constitution that applies to America, and we're not under international law as they would like it to be, and we're a sovereign nation, and we're going to remain a sovereign nation. I think Trump is moving in that direction, and that's a good thing. And we need to continue down that road. We need to get out of the UN, get the UN out of New York, and get us out of the UN.
Yeah, absolutely. And, I think the key to our national sovereignty is not to allow any other agency or any other group of people to impinge further on our sovereignty, on our concepts of sovereignty, both national, state, and individual sovereignty. And so we really need to reassert that, and I see that happening for the first time in a very long time. I see, in Elias, you alluded to this earlier, but I see a shift back, a focus back to people understanding that, boy, we've been going down the wrong road for a long time, and we're finally starting to awaken to the reality that a lot of things have happened in this country that have destroyed our liberty, and it's time to put a stop to it. What do you think about that, Elias?
Well, totally. It is past time to rise up in our minds and understand what freedom requires, and that being personal responsibility, that personal responsibility to act on one's conscience. And know fully that our Constitution is so put together. Every part of it interfaces to the overall intent of the founders, so that we can live as conscientious people, we can live as moral people, and we can observe the impulses of our own conscience when we are confronted by a rogue government oppressing our neighbor. It is our duty and our right to stand up, get on a jury, tell the judge not guilty, no matter what the judge tells the jury in their instructions. The jury has this power. And we have a duty individually, a responsibility, a personal responsibility, to participate in that system. Because I will tell you, I'm done with politics. It is not going to happen through there is no political solution to the problems created by politics. So we have to take life and the matter of justice in our own hands as people, as good neighbors on the land, and do what we can through juries to stop oppressive decisions and unjust punishment and abuses of our highest law of the land with some of these ridiculous laws they're trying to enforce. That would be my word on the matter.
Mm-hmm. Well, that's good. That's a good take on it. I'd like to. We're getting close to the end of the program, so I would like to give both of you gentlemen an opportunity to do a little plug for your own websites, for your own organizations. Don, do you want to be the first to talk about the Fully Informed Jury Association?
Yeah. The website is www.fija.org, fija.org, and that's the best way to practice. There is a phone number here, but the organization is scattered around Montana. It's probably not the best way to go about getting through.
Okay.
So. Yeah, just go to the website, and there's a contact form there, and you can buy ready-made brochures and other materials, or there's brochure masters that you can print out and make your own literature and distribute it in front of courthouses and wherever people congregate. We caution that people should not include any information about any particular trials that are underway. This is just general information that FEJA puts out, and it's up to the jurors to apply it to particular trials.
Right. And again, the idea here is not to unfairly or unjustly change the outcome of a trial. Is to ensure that we do have a fair and just system of a legal system under the court system, and that we assure that with citizen participation and an understanding of their role as a fully informed juror.
Right.
That's exactly what this whole program has been about. Elias, would you like to tell our listeners a little bit about the mental militia and some of the projects that you've been working on as well?
Don, this is an enigma. We are an organization that is not organized. I mean, a disorganized organization. It's basically an idea that I had back in 1999 when I got online the first time and started reading. Prior to that, I was very busily involved in my business, and I just didn't pay attention to what was going on with my country. Getting online, I realized soon that we needed to regiment our mental states in order to see more clearly how we can protect our freedoms as Americans. And so I created this group called the Mental Militia. It's been online ever since in one venue or another. I have a website called thementalmilitia.net. I have a forum that's been out there since 2003 that doesn't get much traffic these days, but look at thementalmilitia.com. Anybody can join there and type up their own opinions. Otherwise, we're not doing much. I am doing a DVD for the Jeanette Pennicum family that the Mental Militia is going to donate 100 copies of this DVD so she can sell them to help pay her legal expenses. And
Elias, I hate to do this, but I'm going to have to stop it at this because we do have our commercial break at the hour coming on. But I want to thank both of you gentlemen for participating on this program, and hope that you will continue the great work that you're doing.
Thank you.
Working from behind the scenes, controlling everything, from the daily news we read to the politicians.